order went into effect on the 16th, which was a Monday. Lisa Tucker did a phenomenal job getting notice out to everyone who was planning on coming into calendar call that Monday, telling them not to call. And by Wednesday, we were actually holding our first WebEx hearing. And we've been holding hearings in Civil Superior Court at least 3, if not 4 days a week since that time. When we first started out, consent of both parties was required. If you're familiar with Rule 6 of the General Rules of Practice, which most people don't ever have an opportunity to look at that, Rule 6 of the General Rules of Practice allows a trial judge in his or her discretion to order a hearing be conducted telephonically. If one of the parties wants a written record, they can request that it be recorded for purposes of preserving the record. We inquired of Justice Beasley if she intended her directives to supersede that, and the response we got was no. And then we had the order that came out last week, which now WebEx hearings can be conducted without the consent of the parties. And in fact, that is starting now. If anyone wants a hearing via WebEx, they can request it. The other side can object for good cause. And if good cause is shown, we won't hold it via WebEx. A number of people have either withdrawn consent or expressed concerns that their clients might be prejudiced because of WebEx hearings. I will tell you, we have heard constitutional issues dealing with the imprisonment or constitutional violation, alleged constitutional violations with respect to prisoners, with respect to the Second Amendment and pistol permits. We have held hearings related to petitions to judicial review of elections. We have had some extremely substantive hearings in various 2.1 cases. We've done a lot of minor settlements, which actually works out well because it's less intrusive on the minor in terms of their time and subjecting them to a courtroom full of adults. And we've done a number of motions to transfer structured settlements. So, as well as numerous TROs and preliminary injunctions. So for the judges, it's pretty much business as usual, except our biggest problem in Civil Superior Court has been getting people to come in and ask to be heard. We know there are motions out there because we had calendars, and we saw instances where we had calendars with 40 motions on it, and only six of the cases the parties would consent. Because consent's no longer needed, that's going to be a lot easier. Things are going to change fairly quickly within the next month. And let me tell you what those are, and then I'm going to get back to some of the best practices for these types hearings. Starting June 1st, we are going to do a limited number of in-person hearings, as well as WebEx hearings. WebEx hearings will continue, and they will be the preferred method of, at least in Civil Superior Court, of hearing motions. This is all contingent upon the county putting in a safe distancing plan in our Civil Superior courtrooms, traffic patterns, and things of that nature. There will be no jury trials in June. My best guess is that jury trials won't be allowed until all counties in the state are equipped to handle trials. If you watch the news, there are some jurisdictions in the state in the West that are just now getting their first case of COVID-19. So they are literally 2 weeks behind, 2 months behind us. And it may be, and I can't speak for the Chief Justice, but it may be that she wants to make sure everyone can hold jury trials before we start jury trials. But we will start limited in-person hearings starting June 1st, as long as we can get adequate social distancing in our Civil Superior Court courtrooms. And you'll be able to submit a calendar request and say whether you want WebEx or whether you want in-person live. If you request at WebEx, as I said, the other side can consent, or they can object. And if they can show good cause, the court will order that it be heard in person. Likewise, if someone requests an in-person hearing, if someone objects because of their particular susceptibilities or perhaps the particular susceptibilities of people they live with, and they don't want to come to the courthouse at this time, they can object to that, and then it would proceed via WebEx at that time. One thing we're asking parties to look at that have jury trials or requested jury trials, and they want their trials heard, is to waive and request a bench trial. One of the things that's going to happen when this is lifted, you're going to see a number of trials that are currently on calendars, or calendars get bumped to allow those trials that have had to be passed over to take their place. Probably the exception for that will be our 2.1 and 2.2 cases. So right now, if you want to get on a WebEx calendar, all you need to do is send a calendar request to Lisa Tucker, let her know, obviously, the case and file number and when you want it heard. Right now, pretty much we're only doing WebEx hearings Tuesday, Wednesdays, and Thursdays. Mondays, we're typically reserving for our TROs. At least at this point, if the parties agree, we will get you on. If you called us up on Tuesday and we had a time on Thursday, we'll get you on for a hearing. We've had hearings last from 15 minutes to 4 hours using WebEx. So I think all of our judges have had experience using it and holding hearings. A couple of practice pointers. Rule 12 of the General Rules of Practice. My predecessor, Judge Manning, used to keep hard copies of that up on the bench and would hand them out to attorneys who he thought might not exercise proper courtroom decorum. But Rule 12 applies to WebEx hearings. By way of coincidence, and not that I'm endorsing any show, last night on CBS, there's a show called All Rise about a judge out in California, and they did a virtual, or attempted to do a virtual trial using audio visual. If you happen to see that, counsel cannot act the way the counsel did there. We expect the same decorum that you would have in the courtroom at a WebEx hearing. The only exception we're making is, at least at Civil Superior Court, we're not requiring people to wear business attire. As long as it's business casual, we're fine with that. Would ask that if your clients are going to appear, that they wear something that's appropriate. I've seen everything from bath caps on heads to halter tops. And while I understand that may be all some people have, I think everybody needs to keep in mind, when I hold a hearing and when all our Superior Court judges hold hearings, we're actually sitting in the courtroom. We're sitting in the courtroom and the only person present is the clerk who is recording. Sometimes we'll have a court reporter take it down. If you're going to the hearing itself, a couple of things. If you've had much experience with Zoom or WebEx, you will know that the more mics that are unmuted, the greater the chance for feedback. So always, if you're not speaking, make sure you have your mic muted, because that's when it creates problems. We request that people, if you're going to have exhibits, that you email those to the court and the parties ahead of time, as well as all briefs or other memoranda. Let me see. If you need a file, right now the court staff, or let me say this, the judge and the judicial staff, we are not allowed to pull files at this time. So if you need a copy of a file, you're going to need to email the file access email accounts for the clerk. For civil files, that's wakecivilclerk.filerequest at nccourts.org. For criminal files, it's waitcriminalclerk.filerequest at nccourts.org. If it's estates, it's wait.estates.copyrequest at nccourts.org. In special proceedings, it's wait.sp.copyrequest at nccourts.org. I'm trying to flip pages because I think kudos need to go out, one, to our trial court administrator, Kelly Myers, and our trial court coordinator, Lisa Tucker. Wake has really led the way and set the standard for the other counties in the state. A lot of counties and major counties just started holding WebEx hearings last week. Some are just starting this week. And with all the continuation of operation plans that a lot of counties have instituted, have been based off the model that Kelly and Judge Ridgway and Judge Rader and our DA Lauren Freeman and the clerk all came up with. And it's served us well. And it's just been, it's been a Herculean effort on their part, not only to do that, but they've all been made part of task force as to how we go in the future by the Chief Justice. So if you're trying to get in touch with them to set up a hearing and it takes them a little bit of time to respond, please remember that they have a lot on them. We have been involved in training other jurisdictions, not only judges helping train other judges, but TCAs and judges training other TCAs and judges. So our time is being divided. Let me assure you, we are not sitting around doing nothing. And I want to get to, all right. So once again, once we hit June 1st, probably what we will do is have WebEx hearings on Wednesdays and Thursdays. And you'll submit your calendar request directly to Lisa Tucker, indicating whether you're requesting WebEx or in-person hearings. More than likely do the live hearings on Tuesday. We have not finalized the filing deadlines yet because we're still trying to work out to make sure people have enough time to object to either a WebEx hearing or an in-person hearing to let the judge decide and give parties the proper notice. And we are not going to do split proceedings where some parties appear in person and some parties appear WebEx. One, I think that would be inherently unfair to the people who are appearing WebEx. And I think if that happened, they would all default to an in-person hearing because most attorneys, knowing that the other attorney is going to be down in the courtroom, they're going to want to be down there in the courtroom as well. And we're still trying to limit the amount of individuals that will be in the courtroom. We will have restraints on the occupancy capacity of courtrooms. If a courtroom typically holds 100 people and we're doing an in-person hearing, the county may only want us to allow 20 people in, and that would include the court, the bailiff, and our court reporter if we have one, and our clerk. So that means there would be room for 16 or 17 other individuals, meaning attorneys, parties. And under the North Carolina Constitution, I think it's Section 18, Article 1, our proceedings are open to the public. Not only our WebEx proceedings, but our in-person proceedings. We have to let the public in. On our WebEx proceedings, when we publish a calendar, we put on the calendar that they're open to the public, and anybody wishing to view any proceeding may contact Lisa Tucker, and they'll be sent a link to those. So you may get on a hearing and realize that it's just you thought it was going to be you and the attorney on the other side, and there may be 5 or 10 other people viewing the proceeding. Sometimes it may be news media, it may be individuals from other jurisdictions who are just interested in how things are proceeding. But we will not close the courtroom off. We will always allow at least a limited number of the public involved, so long as we are in compliance what the county's requiring of the occupancy load. So what we would request in those instances where you do get an in-person hearing, please, you don't need to bring 4 people from your office if only one person is going to argue. In case you haven't heard, the rotation of civil superior court judges has been suspended. So the Wake County Superior Court judges will all be here in Wake County. They are all here now and will all be here the next 6 months. Calendar calls, if we have calendar calls, we're going to start doing those by WebEx until further notice. But I think at this point, the decision is being made. We probably will not need calendar calls since people putting their names up for the calendar, hopefully, since there'll probably be about a 2-week deadline to get that calendar request in, they would at least have notified us to get off that calendar if they need to within that 2-week period, as opposed to having requested the calendar date months before and then forgetting about it once you settle your case. We're going to have an admin calendar the end of June. It may very well be WebEx. We haven't decided yet, but it's going to be for all those cases that came up for trial during the period in which it's going to be came up for trial from March 16th until June 30th. When those cases that have continued, attorneys have been instructed to go ahead and submit a new case management order, and the admin calendar is going to be for those individuals or those cases in which a admin or new case management order has not been proposed. Attendance will be mandatory, and you will walk out or click out of that hearing with a new case management order. And absent some exigent circumstances, we will more than likely require people abide by that order. Going back to the hearings before the WebEx hearings, if you want clients to attend, if you want other observers to attend, all you need to do is give us their email address, and we will make sure that we will send them a link. What we do, we typically ask that anyone except the attorneys mute their video, and all attorneys keep their audio muted unless they are the ones speaking. Right now, at least in Civil Superior Court, we have not conducted any WebEx hearings in which testimony is required. That is, and my best guess is right now that will continue. And the reason is, as you can tell, looking at everybody that's got their screen up, we all look a little different based off a camera angle, based off of lighting, and that could really skew a judge's ability to determine the credibility of individuals. So in Civil Superior Court, if we're going to have an evidentiary hearing, we will more than likely do it in person. Obviously, if you want to get a trial sooner rather than later, consent to a bench trial, and in the court, and I think those will get done fairly quickly. I'm going to, I will get the emails. What I'll do is while Judge Walczyk talks, I'm going to get those emails to the file access and try and post those on the chat. And if you have any questions, you can put them on chat. And I think we may have some time at the end. But with, I'm going to go ahead and turn it over to Judge Walczyk now.
All right, thank you, Judge. I want to thank you guys all for being on this call, and thank you all for your patience. I mean, there probably should have been a manual for a pandemic, but there wasn't. And so we are all just doing the best that we can to, continue to make the courts accessible, but also, do things the right way. We just got the new directive from Justice Beasley, so I'm going to try to give you as much information as I can about what's going to happen going forward, but I'm also going to tell you about what we've been doing now. I think there is a concern with Justice Beasley's order that we're going to change it up on you right now, and that's not what we're going to do, at least in family court. The intention is not to require mandatory hearings before June 1. So in family court, everything up until June 1 has already been removed from the calendar. So those things are going to continue to be handled the way we've been handling them. You guys either need to consent to a remote hearing or consent to the resolution of the case, or it's going to be reset. So I just wanted to talk a little bit about the kinds of things that we're doing now. I agree with Judge Shirley. I mean, Wake County was really on the front end of this. We got out ahead of it and we were able to put things in place. In family court, you can do almost any kind of motion, pretrial conference, any legal motion can be done by WebEx if both parties consent. You can do temporary custody hearings, temporary child support hearings. All of those things can be done as long as both parties consent. We are shying away from the financial matters, but probably you could ask for that, and if everybody agreed, we could probably make it happen. Judicial settlement conferences are available for any kind of claim. So if you want a judicial settlement conference, we have additional judges who are not your assigned judge who can help you try to resolve it, whatever your claim is, through judicial settlement conference. Custody mediation and custody mediation orientation is still available. All of that is remote. That's happening, you know, pretty much whether you consent or not. I'm going to pass on to you that Iris is not in the office now. So there is a email set up if you want to do or go back to custody mediation. You can use this email, and all the mediators are helping with the administration of mediation. And that is d10.custodymediation@nccourts.org. And I can include that in the list of emails that we disperse to everybody. We're also doing summary judgment divorces on Fridays. If you want to do a summary judgment divorce, not everybody has to be there. You can waive appearance on the WebEx if you're the non-moving party, but everybody has to agree to do it remotely still. Those are done through Tasha O'Neill in the clerk's office. If you want to get on that calendar, you need to email her. We are doing a limited amount of domestic violence stuff on WebEx. If you have a consent DVPO return, or if everybody's agreeing to do some kind of hearing, you can contact the DV unit, or she's probably going to get upset when I say this, you could probably contact Judge Eagles directly to set it up. Abuse, neglect, and dependency, they are doing non-secure custody hearings and review hearings. I think in those cases, the parties have a choice on how they want to do it. If they want to do it by WebEx or live, those are being done, the non-secure custody hearings. The reviews, which normally are done every 3 to 6 months, those are being done via WebEx, and calendar calls are currently being done in abuse, neglect, and dependency on remotely. So Sharon Kanapka in the family court office is the person that you would contact if you have something with A&D to be heard. So after June 1, obviously we're going to reconsider the mandatoriness of the hearings. The new directive allows you to object, and the court would have to make a determination about whether there was good cause to object to a remote hearing. Since this just came out on Friday, we don't have an entire plan in place, but I think you can safely anticipate that almost all of our calendar calls, we're shooting to have those be remote so that no one would come down to calendar call. Our plan is to tell folks who have attorneys, you know, tell your clients not to come to calendar call. We don't need anybody in the courthouse until it's time for their trial. So we're hoping to have as few people as possible in the courtroom during the calendar call, and then we would schedule the day for live hearings as we go through the day. There will probably also be some remote hearings, but I anticipate that those would be mostly temporary hearings. I don't see any, unlike Superior Court, we are going to be doing hearings that are involve testimony, but they would be non-prejudicial hearings. I don't think you're going to see any permanent custody trials or alimony trials or ED trials being heard remotely. One, it's really difficult for those of you who have been doing this for a while now. It's difficult to have a hearing remotely that lasts 6 hours. People's internet cut out. You know, you can't hear everybody, the dog's barking in the background. So it's just difficult to do a full day trial remotely. So I anticipate it will be temporary matters, short things. Summary judgment divorces may continue to be remotely after June 1. I think it's working well, and it's something that can be done easily, and then you guys don't have to come down to court. Even if it's not consented to, we might continue to do those in the future remotely. So we're working on that. The current, if you're consenting now, and even after June 1, there's probably going to be some limitations on the kind of remote hearing we can have. Currently, through June 1, we've limited the time, we've limited the exhibits. You can look at the protocols and see what all the limits are. We're also trying to do them Tuesdays, Wednesdays, and Thursdays so that we have Monday to try to get everything ready for the judge as far as files and exhibits and those things. If you need to have a remote hearing, the way to set it up is to contact the appropriate person. For example, in family court, we're talking about Yvette, and if you've got divorce, you're talking about Tasha. If you've got A&D, you're talking about Sharon, and if you've got DV, you're talking about the DV unit. And you need to let them know. The hardest thing for us is collecting all the current email addresses for people. So if you have witnesses, parties, we need all of that information to send the invitation to them. Now, my hope is in the future, we can find a way to do calendar calls where we don't have to send invitations to anybody. We just have a meeting room and people can just pop in and out of the room. But for right now, we're doing all invitations. So we have to have everyone's address and we have to be able to contact them and get them on. We needed exhibits in advance. If the judge is allowing exhibits, we need them ahead of time. Even though you can share your screens on these WebEx hearings, it's good to have it in advance, and it's fair to the other party to basically see what you're going to try to admit before everybody sees it at once. So we're asking to have all the exhibits submitted in advance. For divorce and other summary judgment motions, be prepared to have a judgment for the judge to sign. You can send that in advance. If the judgments are incorrect or there's problems with it, make sure you're fixing all the typos, because it's going to be much more difficult to fix it if you are not present in the courtroom with us. And probably what will happen is we would just not grant your motion for summary judgment if we have a vital statistics sheet that's incorrect, or if we have the wrong data separation on there, we're not going to fix it for you. So make sure you pay attention to your documents. Judge Shirley covered most of the best practices I was going to talk about. I will say, please practice in advance if you have a hearing. Make sure the internet speed is fast enough that your client doesn't keep freezing up when they're trying to talk or you're trying to talk. Make sure you don't have the TV on in the background. We had that happen once. Make sure the background is okay. You don't have some illegal substance behind you in the background. Just go through those things and practice it. Decide whether you want to be in the same room with your client or whether you want your client in a separate room. If you're in separate rooms, you'll have to have a way to communicate privately with your client. No one is going to be allowed to communicate with their clients while they testify, and no one can communicate with witnesses. That's just going to be one of the rules. But if your client is asking you questions about exhibits or whatever, you need to do that offline. So just basic things, look in the camera, try to look in the camera when you're speaking, dress appropriately, like the judge said. Make sure your forms are correct. Make sure you know how to share exhibits with everybody if you need to. Those are just basic things. I just wanted to talk a little bit about going forward. I think that's the question on everybody's mind, what's going to happen throughout the rest of the year. And I don't have a crystal ball, but I can tell you some things. I mean, this pandemic is a game changer for us, for you, for the whole profession. I've been on a lot of webinars with chief justices from around the country, and everyone is aware that things won't go back to the way they were on some level. So I think electronic filing for North Carolina is going to become a #1 priority. Wake County was a pilot for this program and it was coming, but I foresee that there's going to be a huge push to have this put in place. It will be mandatory. They did start, we have a vendor, they are drafting the software for it, and we're working now on rules to implement it statewide, but you need to know that electronic filing is coming. And along with electronic filing, I think electronic signatures are going to come, and, notaries will be phased out in favor of statements made under penalty of perjury, verifications and things. I think that is all going to change in the future. on a temporary basis. I think calendar calls are going to be completely different. You know, everything's going to be remote that we can do, at least through the fall. There'll be some level of remote hearings that everyone will be required to do. So you've got to get familiar with remote hearings. I think that there's going to be modifications to civil procedure rules on service. They're already working on a modification to Rule 5. I mean, temporarily email is permitted, but I think there may be some modifications to Rule 4 and Rule 5 coming in the future. There'll also be, in my opinion, more laws that will deal with remote hearings and what things are allowed to be heard remotely and what things are not allowed to be heard remotely. And really, you know, scary as this sounds, I think the nation, at least the legal professions, are talking about jury trials and how will jury trials be affected by this. I was on a webinar last week in Texas. Has a whole movement to try to modify the way they do jury trials. And I don't know if they're talking about a smaller number of jurors or if they're talking about plexiglass in between each juror. You know, I think grand juries, I think people are looking at all of these things and how can we address this pandemic, because I think everybody believes that this pandemic is going to be around for a while. And so people are just, the whole thing is being shook up and everybody's trying to come up with ideas and ways to address this. So I think we will be without jury trials for a period of time in Wake County. But at least with respect to hearings, I agree with Judge Shirley. We're going to go back to some live hearings by June 1. We're also going to have some remote hearings after June 1. So it will be sort of a mishmash, and our calendaring system is, you know, we're going to have to work on case management because we got a lot of different hands in the pot, and we're always trying to make cases move and get you guys to resolve these things, but it's become much more difficult with all these different parameters and different ways to do things. So I don't want to say too much more except to answer your questions. I haven't really been following the chat, but if you guys have questions, that's what we're here for. You know, we don't have all the answers because we don't really have a plan in place yet, but we will soon. And if you want to ask questions, we'll do the best we can to answer them.
All right. It appears there's a question about default judgments. Do they need to be heard in court due to no consent from the non-responsive party? First of all, I think it's 55, is it C3 or B3 that basically says you can have obtain a default judgment without a hearing if in your default judgment you give the defendant the requisite notice of 30 days that if they don't respond, it can be entered without a hearing. The other thing is if entry of default has been entered, I think the case law is fairly clear after that they're no longer entitled to notice.
Judge Shirley, I think they should also be aware though that all the timelines have been suspended till June 1. So right now, unless you were eligible for a default hearing way before all this started, you're not going to get one now anyway, because the time to answer and all of the deadlines will go through June 1.
Well, and the simple answer is the Chief Justice has said that consent is no longer required. They can object, and they have to show good cause in order to prohibit a WebEx hearing. But right now, consent is just simply not required. I think the Chief Justice's order that came out last week made that perfectly clear.
So I see a question on there about pro se divorces. Our plan with pro se divorces is to run morning and afternoon sessions on June 19th, and I think whatever the following week is, look that up, June 19th and June 26th right now. Sarah Fisher is currently rescheduling the people who got bumped, the pro se divorces who got bumped. I don't know if we're gonna have to cap them because of the number of the people in the courtroom, and we're gonna have 2 courtrooms running. So we'll have probably 5B and 5C running, and it will run in the morning and the afternoon. And then the plan hopefully is to have the attorney divorces be remote. So only the pro se parties would be in the courtroom and we can spread them out. So technically divorces could start beginning June, but we're waiting to see exactly how many live cases we're going to be permitted to have. But I think you can plan on the 19th and the 26th. Definitely.
Thank you.
Everybody, be sure to mute your mics, please.
Anyway, so I hope that answers that question. Yes, they'll be starting up in June.
All right, there's a question. Can we request a WebEx hearing if the other side does not have counsel yet and have not responded to the complaint? If you could have requested an in-person hearing, you can request a WebEx hearing. If you couldn't request an in-person hearing, you're not going to get a WebEx hearing. I mean, a WebEx hearing it doesn't add to or subtract. It merely takes the place of appearing in person in court, at least from the from the superior court standpoint.
Thank you so much. You have a wonderful evening.
And if you're talking about district court stuff with that same question, you know, we're going to still have our calendar. So you would basically just get on our calendar and you know, if somebody's asking to do a remote hearing because they can't come into the courthouse, then we would consider that probably. And like I said, we don't have a plan put in place for that, but we still are going to have our normal calendaring system. We're just going to have a cap on the number of cases that we set per day. And we're still working on 2A. You know, it's possible that we would have a remote 2A calendar, but I can't plan that just yet. So we're working on that.
All right, the concern is you don't necessarily have an email address for the defendant. Well, if you're going to request a WebEx hearing, you're going to have to mail the defendant a copy of your request for the hearing to the place, presumably to the address which they were served. In that, you would just need to request from them an email address so that they can, so that the court can make sure that they attend the hearing or are given an opportunity to attend.
Judge Shirley, I don't know. There's a question about small claims that I don't know the answer to. I think that there will be, there is a task force put in place that's trying to talk about exactly how statewide we would reopen. And I anticipate that there'll be some guidance on small claims, but I just don't know the answer to that question.
I don't know either. Should we expect to be in court on June 1 as if it were pre-pandemic, or is this going to be the new normal until further notice? Well, I think you should only expect to be in court if you have something calendared and you're told to be there and it's an in-person and you've been told it's an in-person hearing.
Yeah, I can't speak for 5B because I'm assuming they're going to do remote calendar calls as well, but I don't know that for certain. Judge Sasser is working on that. In domestic court, you would be remotely on a calendar call, so you wouldn't actually have to be in court. During the calendar call, we would tell you when to report and we would make a determination about whether it would be a remote hearing or a live hearing. So you wouldn't just show up like you normally would, but the calendar will be set. And if you're on the calendar, you'll need to figure out, you know, what you're if you want a live hearing, if you want a remote hearing, or if you're going to settle it.
All right, Mr. Toddy, that's the law enforcement recording request. Is that correct? I recognize 1.4A. He wants to speak to the law enforcement recording request and hearings going forward. We will more than likely do those remotely. For the most part, they have been, I think with the exception of those involving Mr. Hinton, those have pretty much been uncontested hearings, but we would probably, unless, I think we would probably do those remotely unless the court feels that there's an absolute need for a hearing.
So
Got the
again, I'm not the administrator. Sorry to interrupt, but everybody please mute your microphone. I think there's an iPhone that is pretty loud. So, and if Colleen, if you're there, I think you can mute all of us since you're the administrator.
Yeah, I'll mute everybody now. And if you have a question that you want to answer, just, I guess, if you can unmute yourself if you're not typing in the chat, and then politely mute yourself when you're done.
On the special proceeding questions, I'm not aware of, because those are all done by the clerk's office.
Okay, yeah. Just going back to the question about the summary ejectment, I do think the task force is working on that, and there is a new COVID-19 task force. We have some Wake County people on that task force, so that's great. And when we get more guidance on those kinds of things, what we've been doing is posting COVID-19 updates on the nccourts.website. So just watch for those updates, and as we get answers to these questions for you that we can't answer today, it will be online.
You know, I think it's important. The remote hearings are here to stay in one form or another. And as I indicated, I think we're going to seriously take a look at minor settlements. It will just take away from the disruption of taking kids out of school, prevent them from having to appear in front of a bunch of people they don't know. One thing I want to make clear is WebEx is not going to be an excuse for attorneys out of state who want to appear pro hoc from not coming to our courtrooms. I think the general consensus among judges is that if you're from out of state and you want to be admitted pro hoc, you're going to come to our courtroom. That was true with telephonic hearings, and I believe most judges will hold that true for out of state counsel who've been admitted pro hoc. And again, we're not going to, we're not going to let it be an excuse for people not to show up in our courtrooms. There are very few cases in North Carolina that North Carolina counsel are not competent to handle on their own.
So just one other thing I want to mention. I've had some questions in the past and just today about which, like why are we using WebEx versus Zoom or whatever. We have chosen, at least in district court, we're going to use WebEx as much as possible. I know people are not as familiar with WebEx as Zoom or Microsoft Teams or those other ones, but that's the one that our staff is prepped on. We have tech support for WebEx, and it's, I think, probably more secure than Zoom. So there's various reasons why we're using it. Some of the delay that we've had in getting these up and running is the equipment. So, not everybody who works in the clerk's office has a webcam or has a laptop so that we can do these things. And so it's taken some time to get those things in place. But the great thing is that the way we've been able to do it is the staff can set up some of these meetings and then make the judge the host, so the judge can control the meeting and record the meeting. But it's important that you pay attention to the protocols about the recording and all that. Some of that is being directed by how WebEx works. So we're going to stick primarily with WebEx. I mean, obviously, I have used Zoom for things like this and CLEs, but as far as the hearings go, it will probably be just WebEx now. There's a possibility that for calendar call, we may use something else if we can find something else that's better, but for the most part, we're sticking with that.
With respect to WebEx, there is no cost. We send you a link, and you just follow the instructions on the link. You don't have to download it on your computer, I don't believe. You can actually download a WebEx app on your smartphone. I've had hearings where both the attorneys and clients have appeared via cell phone. So if you have a cell phone, you can do a WebEx meeting. I think one of the reasons we use WebEx is it's been approved by the AOC, and I think it is since it's a Cisco product, the encryption is much better, than what we have or what you see in Zoom and the problems that have been reported with Zoom. But I think with respect county to county, they should be using WebEx. The only official function that we use that we as Superior Court judges are using Zoom for are we can do search warrants via video teleconferencing, and we're using Zoom for those. But everything else we're using WebEx.
So people can continue to send messages by chat. I'd just like to take a minute to thank the judges for their time today. And I want to do a little practice. This is sort of serious and overwhelming, I think, for practitioners, particularly older ones like me, but grateful that we're all in this together. To end it on a light note, we did a little background check on Judge Walczyk and Judge Shirley to find out what their childhood nicknames were. And so I'm going to play a little game to see who's paying attention out there. We've got 4 nicknames. One is Judge Shirley's childhood nickname. One is Judge Walczyk's, and 2 are fake nicknames. So I'm going to call out the nicknames. You can write them down. And then I'm going to call on one person randomly. The first person to get it right gets a surprise. Okay, you guys ready? Okay, the first nickname is Baby Scooter, S-C-O-O-T-E-R, Baby Scooter. The second nickname is Christy, C-H-R-I-S-T-I, Christy. The third nickname is Augie Doggie, A-U-G-G-I-E-D-O-G-G-I-E, Augie Doggie. And the last name is Bunny Rabbit, okay? So I'm gonna see on my screen, it looks like, is Robert Ponton out there? Can you unmute yourself, Robert? You may have to do it for
There you
me.
go. Is that better?
Yeah. So Robert, you get the first shot. Which nickname is Judge Shirley?
Baby Scooter.
Bah, Robert's wrong. Which one is Judge Walczyk?
Do I keep going?
Yeah, you get a second.
Okay. Bunny Rabbit.
Bah, he's wrong.
Well,
Good
that's
try,
no
Robert.
shock with that.
So you miss out on the Chick-fil-A gift certificate.
Well, I'm sorry.
What about Katie King? Are you out there, Katie? Is Katie paying attention?
I am. Hey, Alice.
How are you today?
I'm good. How are you?
Doing great. First Zoom mediation or first Zoom CLE, and I'm pretty happy about it. Can you tell us, did you hear Robert's answers?
Yeah, aren't there only 2 options left?
Yeah, that's why I was thinking it would be a really good question for you. I thought you might be able to get it.
I appreciate your confidence in me. I think I got this.
Okay, go for it.
All right. So Augie Doggie must be Judge Shirley. And then I think the other one was Christy for Judge Walczyk.
Great job, Katie.
Thanks.
So your prize is that you get to present at the Family Law CLE in August, and we'll get you your topic. Okay. Colleen will be on that tomorrow. And Robert, I'm sorry you missed out on that.
Oh, yeah, I've done my bit.
Seriously, guys, thank you so much. Judge Walczyk and Judge Shirley, you guys are great to do this. We know you have a lot on your plate. Super glad that we got this. And Colleen and Whitney, thank you for everything you do. Really grateful that we're keeping the CLEs going. And we've got another one May the 7th.